name's Jason Miller. I'm here representing Jason and Annie Retterath. Your Honors, this case is about due process and the effects of the failure to receive due process, consistent with the Iowa Due Process Clause and the United States Constitution Due Process Clause. Specifically in this case, my clients, Jason and Annie Retterath, did not receive notice of the filing of a foreign judgment here in Iowa, a judgment from the state of Florida. And my clients are residents of the state of Florida. As a result, they did not have the opportunity to advance the fact that the property in question was exempt from levy under the laws of the state of Florida.
Sir, don't you just disagree with the notice that you received according to Iowa statute? You just don't, according to your position, mailing it was not sufficient in your opinion?
Well, we believe there's three different due process problems. Mailing is one. So in order to affirm the district court's ruling that there was no due process problem in this case, we believe this court would have to determine, one, that service by regular mail, which this court has already determined in War Eagle case, was sufficient in this case, that's all the notice my clients deserved.
But this is a collection case, and War was about initial, I think it was a forcible entry and detainer case. Is that correct?
That is correct. It was an FED case, and
Okay.
This is a post-judgment case, and I'll get to that distinction.
But on the mailing one, I want to jump to the point on that. Mailing is what the Iowa statute provides, correct?
That's correct.
So are you challenging that statute as being unconstitutional?
Absolutely. We're
Okay.
challenging the statute's mailing provision as being unconstitutional in this case. And the distinction you make, Your Honor, is, I think, the appropriate distinction. So nationally, there's case law that discusses what type of notice is due someone post-judgment. So there's been a judgment, and now there's enforcement of that judgment, and what type of notice is required. We submit that the notice that the Iowa statute, Chapter 626A, provides, which is just simple notice by regular mail, this court has already determined and stated bluntly that that type of notice is mere lip service.
In the forcible entry and detainer case, but this is not similar to that, is it?
Well, it is similar to that in that the mailing, so the issue the court had in War Eagle was that that type of notice, mailing, isn't calculated to actually reach the person in question. And that applies whether you're talking about post-judgment enforcement of a prior judgment, in this case a Florida judgment, or whether you're applying a FED case. In either situation, putting it in the mail, as this court determined in War Eagle, isn't sufficient.
What's the record on? Did your client actually receive it?
No. Which is why they didn't challenge this. The charging order was entered, and we had to move to vacate months later. That was the only procedural option we had. And so that's what I'm saying when I started off saying this case involves the due process notice and what the effect of not receiving it. Our position is the property in question was exempt from levy by Wells Fargo because it's owned in tenants by the entirety. We never got to advance that until the property was already taken. And so, Your Honor, to get back to the mailing question, Justice Christensen, that you raised, that's one of the issues, is regular mail notice, which this court has determined to be insufficient in the context of an FED, okay in this case simply because it's post-judgment. Second question is, from a due process standpoint, the clerk clearly did not comply with Chapter 626A, and the district court just glossed over that and said it's fine, everything was done okay because Wells Fargo ended up mailing it down themselves. Every Iowa case that has addressed issues of extraordinary service has said you have to strictly comply with the mandate for extraordinary service, and here the clerk didn't. So in order to affirm the district court, this court would essentially have to say the clerk's failure doesn't matter, and that part of the statute, 626A, that requires the clerk to docket the mailing is superfluous. It doesn't just, we can ignore that. And that's never been the law of this state. It's definitely an extraordinary manner of service.
Let's take that a little step further. Suppose she had docketed it. How would that have changed your argument?
Well, that's a form of notice itself. I mean, that's a public filing. So And when you read the law, that shall happen according to 626A. It's a requirement the clerk do that. And it is a public filing. It is another way of broadcasting that we are going to be taking action on this foreign judgment. It didn't happen here, and it can't just be glossed over.
The motion was filed too, correct? Which would have been a public filing, the actual initial document filed by the plaintiff?
The motion to, I guess I'm not sure which motion you're referring to.
Well, any document that you say should have been docketed, the document itself was filed too
Absolutely.
in a public filing.
But where the harm comes in is the statute suggests that nothing can be done until the clerk provides, I mean, it's an original notice issue. I mean, the fact that a petition's filed doesn't end the inquiry. You still have to serve it appropriately. And nothing can take place on the case until the service part of it, the notice part of it, has taken place. In here, the notice part of this was lacking. It was serviced by regular mail. It did not get to my clients, and they didn't have an opportunity to contest the taking of their property until it had already happened. And so you get into the question of post-judgment notice. What is required? Iowa really has not spoken to this. When you look outside of the state of Iowa, the Wells Fargo has relied on the Gideon v. Gideon case out of Colorado to suggest that, well, basically, you got due process the first time around when the judgment was entered, so you don't get due process the second time. That line of thinking is based on the Eldridge U.S. Supreme Court decision, and that has largely been displaced by the Matthews v. Eldridge. And I'm sorry, I may have misspoke there earlier. The line of thinking out of Gideon is based on the, sorry, Your Honor, I've cited in my brief, I'm blanking on the case name, but basically this U.S. Supreme Court case that was relied on in the Gideon case has been replaced by the Matthews v. Eldridge case, which places a balancing test, or espouses a balancing test should be followed. And that approach is what most cases across the country have used when trying to assess what type of notice is required post-judgment. And here, when you look at those factors that are supposed to be applied in the balancing test, we submit that what we're asking for here is a form of notice that's calculated to reach the judgment debtor. Our statutes allow for restricted certified mail, the idea that it's actually going to get there. You know, interestingly, in War Eagle, the form of notice that was stricken down as being inconsistent with due process was at least certified mail. Here, we have just standard mail under 626A. It's not much to ask for a return receipt to show that it actually got there. And I would posit as well for the court, why have the mailing in there? If you really don't intend it or care if it gets to the judgment debtor, then why have it there in the first place? It really is lip service to due process. And for that reason, the statute should be stricken down as unconstitutional. The only other statutes that I could locate that allow some sort of service by regular mail, one was the FED statute, it was stricken, and the other is the property tax statute, which is cited in the plaintiff's brief, and that statute has never really been challenged on that ground. And so here, post-War Eagle, the court has the opportunity to correct a problem in its statute and require that judgment debtors get the due process, the minimal amount of due process of simply getting the notice and ensuring that the notice reaches them. And there's not much of a burden on the creditor to do this. We're not suggesting that they need to file a whole new action on the foreign judgment. We're not suggesting that full faith and credit shouldn't be applied to foreign judgments. We're simply saying, please provide the adequate notice.
Your time's up. Can you address the tenancy in entirety, why this is a tenancy in entirety?
Sure, absolutely, Your Honor. So that's a choice of law question to start. So what state's law should apply to that question? The Wells Fargo argues that the law of the state of Iowa should apply to determine the character of the personal property that is owned by the Retterath. Now, I use the term personal property with great effect, I believe, and that is that the legislature, when they enacted Iowa Code Chapter 489 specifically indicated that transferable interests, which is what Wells Fargo took from my client, their distributions, are personal property. When the legislature did that, they're presumed to know the law. The law of Iowa has been since the 1800s that the law to be applied to personal property to determine its character and possessive rights is the law of the domicile of the owner. It's a very clear rule, and it's been in place for a long time. They're advocating now that we should somehow apply a different standard to LLCs than we have to other forms of
But let's
tangible
assume it's Florida law.
property. Okay.
The issue I have is there unity in time? I mean, that seems to be the contention. And why under Florida law is it a unity in time?
Because Florida law specifically recognizes, and I've cited the cases, and there's also a statute, that a married person can convey property that they own by themselves to themselves and their spouse in tenants by the entirety. And the reason is tenants by the entirety is a legal fiction whereby the married couple is their own entity, separate and apart from each other. They are one in marriage. And so when you convey to that, that is a new entity. And Florida law has recognized that you don't need to, and basically back in the early 1900s, this issue came up, and the New York decisions were the ones that were viewed as the majority view in the country. And under the New York decisions, prior to the New York decisions, if you wanted to do this, you had to have a husband typically convey to a straw man. The straw man would then convey to husband and wife tenancies by the entirety. The court said, that's silly. You don't need to have a straw man in the middle. A husband typically convey to a husband and wife tenants by the entireties. You still have the unity of time. And that's the New York decisions as applied in Florida. There's a Florida statute cited in our briefing that specifically says that you can convey tenants by the entirety from one spouse to the other two. So there's really no question under Florida law that the unity of time applies or was satisfied in this case. And I understand it's a legal fiction, effectively, but it's one that's been recognized for a long time. Getting back to the due process issues, I mentioned the clerk issue and not properly documenting it. The last one is that Annie Retterath was provided absolutely no notice here, none. There's nothing in the record to suggest anything was mailed to her and that she was provided any notice, yet she owned this property. And we cited in our brief the Admonson case, which says that when, and that's a homestead right case, but where it's analogous is the property in question wasn't severable. And the court said when you can't sever the property in question, you need to provide notice to both owners of the property. And here, Annie's rights in the property as owner tenants by the entireties is not severable. Therefore, she absolutely needed to be provided notice that her property was going to be taken, and she got none.
I want to get back to the choice of law. Justice Wiggins gave you, even if it's Florida. Regarding Iowa, you seem to kind of dismiss the LLC discussion. I'd like for you to talk about the argument by plaintiff regarding Iowa law applying.
Sure. Plaintiffs rely, or Wells Fargo relies on out-of-state law for the proposition that somehow an LLC's intangible property should be treated differently than this court has always treated intangible property in the state. The fact of the matter is the cases that they're relying on are addressing jurisdictional issues as to whether or not the charging order in place could be brought in the state where it was brought. That's not what we're addressing here. We're talking about what law should be applied to the character of the property that's being made subject of the charging order, the personal property itself. And under Iowa case law, when you're determining the character of that property itself, it has always been the law of the domicile. And so that's a significant distinguishing factor. And the other issue is, in looking what state's law to apply, the district court applied a balancing test out of the restatement conflicts of law, and it skipped the very first part of that test, which is if the statute directs what law should be applied, you should follow the statute. And we posit that the statute absolutely did direct what type of law to apply because it declared that the transferable interest is personal property. And it did that in the light of this court's case law that personal property is governed by the law of the domicile of the owner. So the legislature is presumed to know that. They enact a statute that says it's personal property. That's really as good of a choice of law clause, or at least a implied choice of law clause right there in the statute. And we're asking the court to follow existing precedent rather than depart from existing precedent and carve out an exception for LLC intangible property and to somehow distinguish it from other forms of intangible property. The relevant point to choice of law is it is intangible property, and this court has not treated it differently when trying to assess what law to apply. Your Honors, with that, I reserve the rest of my time for rebuttal. Thank you.
Thank you very much, Mr. Miller. Mr. Moorlach.
May it please the court, John Moorlach for Wells Fargo Equipment Finance. A lot of ground to cover in my time. Starting with the due process, what I'd invite the court to do is just take a step back and ask, well, what would have happened if the clerk of the Chickasaw County Clerk of Court had mailed notice of the registration of a foreign judgment in Iowa to the Retteraths? And by the way, the record is clear, the Retteraths have been at the same address throughout this proceeding and before and up until the entry of judgment in Florida. And I would submit nothing would have happened.
Was the mailing ever returned? Is that in the record?
I'm sorry.
Was the mailing ever returned as undeliverable? Is that in the record?
No.
So the mailing that was made.
I'm sorry, Your Honor. The clerk of the Chickasaw County Court did not mail notice of the
Wells Fargo
registration.
did, correct?
And Wells Fargo did. We looked back. We thought we had, but we were unable to find evidence that the notice of the entry or registration of the foreign judgment was actually mailed to Jason Retterath, the only judgment debtor. But 20-some days later, the application for a charging order was filed and it was mailed.
That's the document I was referring to, I'm sorry. The application for charging, was that mailed?
Yes.
And was it ever received back?
No.
Okay, so it was successfully mailed as far as Wells Fargo is concerned?
Yes, Your Honor.
Thank you.
And I think that question kind of highlights what the Retteraths attempt to do, and that is conflate the statute controlling the registration of foreign judgments and the statute allowing for the charging order to take place. That is, the Retteraths argue that somehow they were unable to lodge their objections to the charging order based on the TBE exemption. But in reality, they got notice of that, and they had hearing of that. The only thing they did not get notice of by the clerk of court was the registration, the original registration of the foreign judgment. And the reason that notice is so important is so that the judgment debtor can challenge the validity, of that judgment. Either was it obtained by fraud, were there shenanigans in Florida? Throughout this case, those objections have never been raised. The only objection has been to the nature of the charging order and whether it's appropriate. Well, the Retteraths got notice of that. And they filed months later an objection to that charging order. Distributions from HES, Homeland Energy Solutions, and to the extent that perhaps Mr. Miller and I could supplement the record for the court, a couple weeks ago, Mr. Miller asked if I could send along the updated collection amounts by Wells Fargo after receiving distributions from HES. And what I was reminded of is that the first distribution or receipt of the first distribution by Wells Fargo wasn't until July of 2016. The charging order was entered on or about January 12th of 2016. So the Retteraths had ample time within that period to even object before the first distribution was received. Of course, now we know we are standing here at a hearing on whether or not those distributions, were proper. And the Retteraths have a remedy. They can be vindicated if this court agrees with them that Florida law controls, that somehow the unity of time was established, et cetera.
That's what I want to talk to you about now. If we could transition to that. The unity in time. Would you agree with me? I think it's the Johnson case that seems kind of clear from the Florida Supreme Court that says what they did can be blessed as creating a tenancy by the entirety.
When we researched the cases, and the cases we've cited, Your Honor, we looked at, and certainly that principle is established in the law, that a spouse can create a tenancy in time, be it just joint tenancy in Iowa or a tenancy by the entireties in Florida, by that kind of transfer. But when we looked at the unity of time analysis involving bank accounts, another form of intangible property in Florida, we looked and found a Florida bankruptcy court decision, as well as a Southern District of Florida decision, and the Beal case that we cite, also the famous footnote number 2 in the Beal case, in which they did not, the Florida Supreme Court did not overturn a finding that unities were not followed under the same circumstances. The district court here cited to the Smart case in Florida, in which there were remarkably similar circumstances. So while in some circumstances it does appear that the unity of time can be met by that kind of transfer from husband to wife to both at the same time, in other circumstances when, and for whatever reason it always tends to be the husband, opens up an account and then later adds his spouse, then the unities are not met. That being said, I'm sorry, yeah.
Go ahead, finish your answer.
That being said, Wells Fargo's position is that the interest in the limited liability company in Iowa is an Iowa interest and not a Florida interest. And so the unity of time argument really doesn't need to be analyzed or decided.
Are you referring to the revised Uniform Limited Liabilities Act?
Yes.
Under your analysis, it seems to me that if a person owns a lot of stocks in companies or limited liability certificates or interests in companies and they're going to get divorced, say, in Arizona or Florida or any other state, do they have to look at the corporate documents of each entity to see which laws apply as to who owns it? I mean, that seems not to be the law. I think, because what you're saying is if these people got divorced, that in order to divide this property, it's not the Florida law that set it up where they're domiciled. They'd have to come back to Iowa. The dissolution court in Florida would have to look at the Iowa law to see who really owned it, and I don't think the world works that way.
I am very thankful. I am not a marital dissolution attorney. I do think that under those circumstances, the interests of, and we're only talking about, and I don't want to conflate ownership in stock with ownership of a membership in an LLC, which comes out of partnership law, and then allows some corporate protections to surround that partnership entity. If those persons had an interest in a partnership in Iowa, and there was a divorce in Florida, that property is Iowa property, and it's well established that interest in a partnership is found in the state where the partnership is formed. So instead of making it analogous to stock, it's really more analogous to ownership in a partnership. And so that Florida couple would have to come to Iowa or interpret Iowa law.
An LLC certificate is more analogous to a stock certificate than it is to a partnership interest.
Respectfully, Your Honor, I don't believe so. A stock certificate, when it's owned, provides all the interest in that corporation for the owner of that stock certificate. So that owner not only has the rights to receive distributions, but also to engage in the governance of the company. Here, under the charging order statute in Iowa, the only interest that Wells Fargo or any other judgment creditor would have available to them is the distribution rights of that member, not the entire interest, so to speak, in the LLC.
Am I correct that the Revised Uniform Limited Liabilities Act has been adopted by Iowa?
Yes.
And is it your position that that is what we should look to for purposes of how to treat this interest?
And more. That's one factor, the operating agreement. But Wells Fargo would direct the court to the recent Colorado Supreme Court decision, McClure decision, as well as the Washington State Court of Appeals decision, Co. And they analyzed the location of the interest in an LLC, not only from the standpoint of the operating agreement, that is the wishes and intent of the creators of that company, like a partnership, but they also looked to the interest and the history of the limited liability, and for shorthand, Your Honor, the Limited Liability Act. They also looked at its history to determine what and where the location of that property interest is located. So they, and that's what we would encourage this court to do, to give some sense of predictability and assurance to Iowa limited liability companies that they will not be subjected to charging orders from foreign states and maybe even countries with similar laws. And so the Colorado Supreme Court looked at partnership law and said, like a partnership, limited liabilities, the interest in a limited liability company is in the state where it was created. And also unlike stocks or other types of personal property which may be subject to levies in the states where they can be found, there's only one remedy or a collection remedy for a judgment creditor, and that's through the charging order that is statutorily created by the state. And so the subject of the charging order is not so much the judgment debtors, but the company itself. And so the Colorado Supreme Court said the state had a real interest in making sure that the interest in that company stayed in Iowa, so that, in Colorado. Similarly here, we encourage the court to adopt a bright line rule about the interest of limited liability companies and its location in order to make sure that limited liability companies in Iowa are not subject to charging orders that may or may not comport with Iowa law from other jurisdictions.
If Iowa law applied, is it going to be a tenancy in common then?
Well, actually, I believe it will be a joint tenancy because there was a transfer later. We have some objections, obviously, about how and when and why the transfers were made, but it seems clear to me by the Homeland Energy Solutions documents that there was a joint tenancy.
If there's a joint tenancy, are you entitled to get all of the proceeds or only his share of the proceeds?
And to be clear, we're only interested in Jason Retterath's interest or distributions from limited liability company.
Even if you're
and
correct,
so
you're talking about half then?
We'd still say that's all of it. I just wanted to make that point that, back to the due process point, that Analia Retterath was not a judgment debtor. They both own and have access to all of it. They testified that they take those distributions and they, deposit them in their joint checking account in Florida. And so to the extent as to Wells Fargo would believe all the distributions are available to Wells Fargo.
If we agree with you that Iowa law applies, are we going to have to determine whether you're entitled to all or half of it? Is that part of what we have to do?
I'm not sure you have to decide that today, Your Honor. I think that's a matter that if it's returned to the district court, I think that would require perhaps more briefing and a decision there.
Mr. Moorlach, I'd like to just ask a very kind of persnickety question related to the record. And we know that first-class mail was utilized here. What does the record show with respect to receipt of the first-class mail notice? First to husband, and then to the wife, I understand there was no effort to notice. But correct me.
All the mailing was directed to Jason Retterath.
Right. And what does the record show in terms of receipt?
The only thing the record will show is our certificates of service of placing those papers in the mail.
So the assumption is that when you put something in first-class mail, it's ordinarily received.
Yes, Your Honor.
And it wasn't returned, correct?
I'm sorry,
And you said it was not returned?
it was not. So, for those reasons and the reasons we've placed in our brief, Wells Fargo request that, Equipment Finance, request that you affirm the district court decision. And
Quick question before the red light goes off. Justice Wiggins gave an example. If Iowa law applies, if it's Florida law, would you agree it's game over for Wells Fargo if there's tenancy in the entirety?
if Florida law applies, it's not game over because Wells Fargo still submits the unity of time requirement was not met. under
Okay,
the
and if the
circumstances.
court is persuaded that it was met by Johnson or maybe some of the other cases, because as you stated, it could go either way. Some of their situations said it was created, sometimes it wasn't. But if there is tenancy by the entirety and Florida law applies, is that a pretty simple resolution?
I believe so, yes, Your Honor.
Thank you.
Is there any rebuttal, Mr. Miller?
Yes, Your Honor, thank you. Counsel for Wells Fargo began his discussion by asking what would have happened had notice been received. And I'd like to read the court an excerpt from the United States District Court for the Central District of Illinois when it's discussing what type of notice needs to be provided post-judgment and why. It states a common rationale given by courts for not following endicott, and that's the U.S. Supreme Court decision I couldn't remember the name of earlier, that basically says if you got due process once, you don't get it again, is that endicott did not consider the possibility that garnishment might deprive the judgment debtor of property exempt from attachment under state law.
Yeah, actually, I'm with you on that, but I'd like to ask the factual question once again about receipt of notice.
Sure.
It was mailed, nobody disputes, I take it, that notices were mailed to the husband, correct? What does the record show? That's what I'm really just interested. The record shows that first-class mail was attempted on the husband, at least, right?
Correct. The
else
record
does it
shows,
show?
the only thing in the record is that there was a certificate of service indicating that it was mailed by
But we don't know
Wells
one way
Fargo.
or the other whether there was whether it was delivered or not, or whether there was a notice of undelivery. Is the record silent on that question?
Well, my clients have indicated in the record that they didn't receive it
They indicate that in the record.
by affidavit. And so they didn't receive it. And that goes to the type of notice. I mean, when you're mailing something by regular mail, and the reason this court found in War Eagle that that wasn't sufficient is it's really, I mean, somebody's child might have picked up the mail and lost it. I mean, there's all kinds of different things that can happen. It may not have gotten there. It may have been lost in the mail. That's why our statutes that talk about notice by mail, other than this one and the FED one and one other, always require that it be done restricted, certified, or at minimum certified. There's got to be some intent to actually get the person notice. And here, there's no dispute that my clients didn't receive notice. I mean, all they can say is we put it in the mail. There's no evidence in the record that it was received. And in fact, the clerk who's supposed to docket the mailing didn't.
Does the record show, with respect to, well, I take it doesn't show the address that was used for first-class mail, or does it show the address?
Your Honor, I'm trying to remember, I know that Wells Fargo has indicated in some of their briefing that they sent it to the address for my clients. I don't recall whether, I mean, it's not on the certificate of service to my memory. Maybe it's, you know, how we do it on our pleadings. We'll put the address down below. I honestly can't remember. Going back to the issue of the type of notice. So the Illinois court decision that I read indicated the reason you should get better notice is so that you can advance the possibility that your property is exempt from execution. We never got the chance to do that. We're here asking the court to vacate an order that has taken a substantial amount of money from my clients rather than being afforded the opportunity to contest it in the first place and have the money. And there's obviously a huge difference to my clients. And that's why you can't say, well, we didn't get you due process, but maybe we'll fix it later. Due process should be provided from the beginning. That's the requirement of due process, notice, at minimum. and my clients did not get that in this case. Going also to the question you had, Justice Wiggins, as to do you have to determine the form of ownership under Iowa law? The district court concluded that ownership was in tenancy in common. That's error. That's wrong. Wells Fargo has agreed that ownership was tenancy with full rights of survivorship, even under Iowa law. We submit that if the court were to apply Iowa law, it should apply the tenancy, but with full rights of survivorship correctly, and only half would be available to Wells Fargo. Each would have a half interest until death, and then obviously transfers in full to the survivor. We do believe you'd have to decide that issue because it was decided by the district court incorrectly. Getting to your question, Your Honor, Justice Christensen, regarding is it game over if Florida law applies? It most definitely is. If Florida law applies, the unity of time as understood under Florida law was satisfied here. You've cited to the case law. There's also a statute that kind of codifies that case, the Johnson case. No question here that ownership was a tenancy by the entireties under Florida law, and under that scenario, this property is exempt from execution. And so getting to the choice of law question as well, and I realize I'm just about out of time, but the cases that were cited...
You are out of time. Why don't you sum up?
Okay.
It goes backwards. I apologize.
No, I apologize, Your Honor. I would ask that the court reverse the district court on all counts and conclude that my clients did not receive due process and return this and void the judgment in full. Thank you, Your Honor.
We'll consider the case submitted. I will tell the council that Justice Cady is unavailable today, but he will participate in this case by reviewing the record, the briefs, etc. So with that, you may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.